What are the requirements for filing a joint Chapter 7 bankruptcy? If you and your spouse are considering filing for bankruptcy together, you are likely wondering what it takes to file a joint Chapter 7 bankruptcy. Let us break down the process and requirements step by step. First, it is important to understand that when a married couple files for bankruptcy together, it is still considered an individual bankruptcy, not a business bankruptcy. This means you will be filing the same forms as individual filers, but you will be doing it jointly. Eligibility and the means test. To file for Chapter 7 bankruptcy, you and your spouse must pass the means test. This test compares your combined household income to the median income of your state. If your combined income is below the median, you are eligible for Chapter 7. However, if it is above the median, you will need to calculate whether you have enough disposable income to repay your debts after subtracting your basic expenses. Forms and documentation. When filing jointly, you will need to complete and submit the same set of forms as individual filers, but with joint information. The key forms include the voluntary petition for individuals filing bankruptcy official form 101, which starts your case and includes basic information about both of you. You will also need to fill out Schedule I income and Schedule J expenses to list your combined income and expenses from all sources. Credit counseling and statement of intentions. Both of you will need to complete a pre-bankruptcy credit counseling course and attach the certificate of completion to your petition. If you have secured debts, such as car loans or mortgages, you will need to file the statement of intentions official form 108 to indicate what you plan to do with these debts. Automatic stay and trustee. Once you file, an automatic stay goes into effect, stopping creditors from contacting you, garnishing your wages, foreclosing on your property, or repossessing your vehicle. A bankruptcy trustee will be appointed to administer your case, gather your non-exempt assets, and sell them to pay off your debts to the extent possible. Meeting of creditors and discharges. You will both need to attend a meeting of creditors, usually within a few months of filing. After this meeting, you will typically receive a bankruptcy discharge, which releases you from personal liability for most of your debts. Most Chapter 7 cases take about 3 to 4 months to complete. Previous bankruptcy discharges. It is also important to note that if either of you has received a discharge in a previous Chapter 7 bankruptcy within the last 8 years, or in a Chapter 13 bankruptcy within the last 6 years, you will not be eligible for a new Chapter 7 discharge. By understanding these requirements and steps, you and your spouse can navigate the process of filing a joint Chapter 7 bankruptcy more smoothly and effectively. Remember to consult with a bankruptcy attorney to ensure all your paperwork is correct and you are making the best decisions for your financial situation.